Welcome to our presentation on self-determination and new generations of rights. We are student members of the Global Human Rights Clinic at the University of Chicago Law School. I'm Christy, and I'm here with Katia and Javiera. Today, we will introduce two types of claims to self-determination, the external and the internal. The external claim to self-determination is a claim of a right to secession. This claim is the right of peoples to determine their own political status and to be free of domination from outsiders, including formation of their own independent state. The theory of self-determination as justifying the secession of a people from its existing mother state as a matter of last resort only in situations where the people is oppressed or where the mother state's government does not legitimately represent the people's interests has remained constant throughout the 20th century development of international law. Two examples of this in present day are Kurdistan and Catalonia. Kurdish people held an independence referendum in 2017, deciding by an overwhelming majority that they wished to separate from Iraq and form an independent state of Kurdistan. Similarly, in 2017, Catalonia voted in an independence referendum in favor of separating from Spain. The central governments of Iraq and Spain have opposed the referenda and have rejected the Kurds in Catalonia's claims of independence. Now I will talk about the international legal framework on self-determination. The UN Charter gave a prominent place to the principle of self-determination in its Article 1. In Article 1, it says, the purposes of the United Nations are to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples. But this last phrase, self-determination of peoples, is ambiguous, and different countries have different views about the meaning of the provision. In the International Covenant on Civil and Political Rights, the ICCPR, two principal articles address the rights relating to groups or members of groups. In Article 1, it recognizes the right of peoples to self-determination, and in Article 27, recognizes the rights of persons belonging to certain minority groups. And it recognizes rights such as the right to be in community with this group, to enjoy your own culture, to profess and practice the group's own religion, and to use its own language. Article 27 presumes these minorities are within an established state. For a bit about the history, historical developments have vastly limited the expansive potential of the right. Before 1919, issues of national identity remained largely irrelevant to determining statehood under international law. But during discussions between the peacemakers at Versailles, the principle of national self-determination was used to draw boundaries in Central and Eastern Europe that matched up with national lines. Especially Western advisors to President Woodrow Wilson were opposed to universalizing this principle for use in delineating new states. But after World War II, the principle began to appear in more international documents, including the UN Charter, like we just saw. The principle of self-determination of peoples was a natural banner for the decolonization movement that swept the globe. It took little time for the principle to transform from certain nationalities forming their own state to the right of colonial territories to break free from the governing state. For some more history, established states and newly independent states throughout Africa were eager to narrowly define the right of self-determination as a right to end colonial status. A resolution adopted by the General Assembly of the United Nations the day after it adopted the 1960 Declaration of Colonial Countries, established the so-called saltwater test. To be eligible for decolonization, this required the presence of salt water between the colony and the colonizing country in order to qualify. This implied that people entitled to independence were limited to inhabitants of discontiguous territories governed by European states. Therefore, the people entitled to self-determination were defined as inhabitants of a colony and not as ethnically distinct groups within those territories or established states. Similarly, At the dawn of decolonization in Africa, the Organization of African Unity adhered to the principle of uti possidetis, developed when Latin American states acquired independence from Spain. This principle, which is Latin for as you possess under law, is a principle of international law that provides that newly formed sovereign states should retain the internal borders that their preceding dependent area that the colonizer delineated before their independence. Post-war interpretation of self-determination recognized one exception to this principle, and that was that established states were understood to forfeit their right to territorial integrity if they abused the rights of racial or religious minorities. For one example of external self-determination, there is the case Katanga's People's Congress v. Zaire. This was in 1995 at the African Commission on Human and People's Rights. Katanga had been an autonomous province before colonization of what is now known as the Democratic Republic of the Congo by Belgium. The Katangese people brought a complaint before the African Commission on Human and People's Rights requesting the commission to recognize a right of secession for Katanga from Zaire, what is now the Democratic Republic of the Congo. The ACHPR emphasized in this case that there were no other violations of human rights other than self-determination, and that the commission was obliged to uphold the sovereignty and territorial integrity of Zaire as a member of the Organization of African Unity. It essentially held that Katanga could only exercise self-determination that was compatible with Zaire's sovereignty and territorial integrity, like establishing a local government or other federal system in Zaire. However, it held with no evidence of other human rights violations, Katanga's request for independence had no merit. Now I will pass it on to Katya.
Thanks so much, Christy. So according to the post-war views that Christy just shared with you, self-determination was largely accomplished through decolonization and emancipation of administrative territories. With virtually unanimous refusal of states to recognize rights of secession, many legal scholars began to consider whether self-determination even had any content anymore. Overall, self-determination lost much of its force. It went from a principle of state-making to simply a correction of the injustice of colonialism. In the 1990s, many international legal experts began to reinvigorate self-determination with a new meaning: democratic governance. Internal self-determination is premised on the view that struggles for autonomy are usually rooted in the failure of domestic institutions to address the interests of minorities. So it attempts to create inclusive political processes through which the entire population can participate in shaping the progress of their country. The international community has begun describing three aspects of an inclusive political process as manifestations of the right. The first is, self-explanatorily, democratic elections. The second is the protection of minority rights. Even when elections are free, minority groups, on account of their size, find few of their views reflected in national policy. Groups effectively excluded in this way are provided protections that focus on their group status, including rights that are political, as well as those that protect their cultural integrity. The third is the construction of autonomy regimes within states. This recognizes that the duties of states to protect the identity of minorities and ensure their effective participation might be, in some cases, best implemented by arrangements for autonomy. Autonomy can be territorial, cultural, and local, and can be more or less extensive. So here's an example of the distinction between internal and external self-determination. The recently introduced Puerto Rico Self-Determination Act recognizes both external and internal self-determination. The Act explicitly lays out that the United States ICCPR obligations extend the right of self-determination to Puerto Ricans, under which they must freely determine their political status and pursue their economic, social, and cultural development. It proposes creating a status convention made of elected Puerto Rican delegates who will come up with long-term solutions for the island's territorial status, whether that be statehood, independence, a free association, or any option other than the current territorial arrangement. In essence, the Act is empowering Puerto Ricans to choose between internal and external self-determination. It allows them to choose between a more politically inclusive process through recognition of their statehood and representation in Congress, which constitutes internal self-determination, or complete independence from the United States, which would constitute external self-determination. And with that, I will hand it to Javiera.
Thank you, Katia. We will now see new generations of rights. Traditionally, we can identify a first generation of rights, which is focused on civil and political rights, and a second generation of focus on social rights and the welfare state. However, there has been subsequent efforts to recognize additional generations of rights, including the right to development, the right to peace, and the right to a healthful environment. Typically, all these rights are claimed for societies or groups, or for individuals as members of those societies and groups. Also, generally, there has been no opposition to recognize these as values, but there has been resistance to qualifying them as binding human rights, since they usually are seen as rights that would cut across state lines and challenge basic assumptions of the state system. However, some argue that there's little harm and potential benefits from these additional covenants, provided it is clear that the pursuit of newer rights does not justify easy sacrifice of older rights. But some argue that this is not needed because existing covenants cover all these rights. But this could be the counter-argument of this would be that they are already specialized covenants, although those covenants were covered in more general covenants before. We will now look into the right to development. This is one of the less resisted rights, but is difficult because of its lack of definition. Is it referred to political development, to social development, or to economic development? Is it referred to individual development or to social development? The 1986 Declaration on the Right to Development declared an inalienable human right, and it connects first and second generation rights with development by affirming that failure to respect human rights is a serious obstacle to development. Equal attention to civil, political, and to economic and social cultural rights is given by the 1986 Declaration on the Right to Development. However, since this is not a convention, there's uncertainty of the significance of the right to development for international law at the moment. We will now see the right to peace. The right to peace, asserted as a human right, has generally been dismissed, and it seems that there's no need to expand from the United Nations Charter. The 1984 Declaration on the Right of Peoples to Peace states that the preservation of the right of peoples to peace constitutes a fundamental obligation of each state. However, there's resistance to bind a state to prefer individual right to peace over national security or reasons of state. But it could be argued that war or policies leading to war would jeopardize established civil and political rights and deviate resources otherwise available to realize economic and social rights. However, this remains under debate. Finally, with regard to the right to a healthy environment, this is seen as a good that states should pursue, and it could be connected to the obligation of realized rights recognized in the Covenant on Economic, Social, and Cultural Rights. It could also be linked to Article 7 of the Covenant on Civil and Political Rights, to the extent that negligent assaults on the environment amount to inhumane treatment of a state's inhabitants. Thank you, and we hope you have enjoyed our presentation.